Good afternoon, everybody, and welcome to our February 28, 2024 webinar on post-judgment custody litigation and how to make it easier, I hope. As you know, family law attorneys in Michigan spend, I think, a bulk of their time on post-judgment custody issues and litigating those issues in the trial court. So today I wanted to introduce two very special guests that I have known for a long time in the family law context, but also specifically in post-judgment custody issues. So first we have Sean Blume, who is an attorney in Macomb County, but he does practice in Oakland, Wayne, St. Clair County, as well as Macomb. And I think I met Sean originally because we served on the Family Law Council together. Welcome, Sean.
Hi.
And then Jackie Dupler, one of my hometown friends. Jackie is a shareholder at Foster Swift in Lansing. And so she spends a lot of her practice time in Ingham, Clinton, and Eaton counties, what we call the Tri-County area, the real Tri-County area. Just kidding. So I already mentioned about how much time we spend on post-judgment custody litigation. So we're going to dive into it because we have a lot to cover today. But I just want to remind everybody that we are recording this, and two, you can post a question on the chat. As a matter of fact, I'll bring up the chat so I can see it. I will try to follow the chat and make sure we have a chance to pose the question to our guests, Jackie and Sean. But you can also use the Q&A function, and I'll see those questions. And if for whatever reason we don't have time to answer it live, we'll do our best to answer it off the webinar afterwards. So let's just get started with getting into the real deal about the first step in any post-judgment custody litigation matter is deciding whether there's enough of a threshold to cross that barrier to get that hearing in the first place. And I don't like spending a lot of time talking here. I really want to hear from Jackie and Sean, but they did ask me to quickly give you the 3 different types of standards for threshold in custody-related matters. So just really quickly, and then I'll be done talking. VARCA, everybody's familiar with VARCA. You have to have obviously proper cause and change of circumstances, but it has to have a significant impact on the child and affect at least one of the best interest factors. The Shade v. Wright standard is a little bit easier to surpass because you're allowed to consider normal life changes in order to have a parenting time modification. And lastly, the K v. CABE standard for conditions on parenting time is the least arduous standard to meet for the threshold, because the idea is that a condition on parenting time will not impact the established custodial environment. So the courts want to make it easier to not only impose them, but also to remove them. So that's kind of the quick little rubric of the 3 different standards that we deal with all the time in our post-judgment custody litigation. So let's dive into this today and start by talking about how are you as attorneys going about to establish the threshold when you're filing your motions. Let's talk about the kind of allegations that you're making, that you need to make in order to get the judge's attention to cross the threshold.
Jackie, you want to start?
Sure. I guess it depends, obviously, what allegations we make based on what we're seeking. If we're looking at addressing conditions on parenting time itself, or custody, I think I'm going to say overarching, my perspective is I don't prefer filing really scant motions that just say, hey, there's a threshold, we've met it, let it happen, or give us this change. I like to put more detail. I think it's really important, especially in counties where the front of the court or the judge might be more detailed in addressing that threshold issue, even without an official hearing. But I think it's important that you do put a significant amount of detail. I know some people don't do that, and I think it's a little bit harder to understand what's going on. And I think that you do see motions get booted pretty quickly if they don't have any information in there.
Are you attaching like exhibits to your motion to prove the allegations that you're making?
Sometimes. I think it depends, but I think a lot of it is in the drafting itself, is making sure that there's some causal relationship, that this is going on, this affects best interest A, C, whatever we're talking about, and to draw some conclusion rather than just say some things have changed. you know, I've seen those motions, but I think that that's a little harder and you're asking the court to do some of your job.
Sean?
Yeah, and I think that question of the exhibits is an interesting one because some courts want the exhibits, and I've even run into some courts referees who don't want to see that many exhibits attached, and they really want to save those for the evidentiary hearing. But like Jackie said, really getting a pleading and you know, there's a balancing, as we all know. We've got kind of a short attention span sometimes for the jurist that's hearing the cases, and so it's really trying to get in there. But as Jackie said, really hitting the points on the best interest factors. I've gotten to a point where mine are getting longer and longer, but they're getting meatier and meatier, and so whereas I think maybe as an early practitioner, I had them long, but with fluff. Now, all the, you know, examples of everything I could think of. Now it's a more concentrated approach of even following the best interest factors and putting those in every motion where I'm challenging custody, so that in the motion, I'm saying, you know, as we talked about, factor A may not be the big one, but when we get to another factor where this does impact it, I really call it out and put it in there.
Now, you both mentioned the best interest. Are you including only the best interest factors that you think are implicated by the evidence you want to present? Or are you addressing all of them because ultimately in filing the motion, your goal is to change custody?
I guess I'll go. I would say that in my initial motion, I think my focus is really the best interest factors that I think are implicated about what's going on. Kind of the balance that Sean was talking about. I don't want to have my motion be excessively long just to show that I know what all of the best interest factors are. I think it's more important to focus on those which we say that there's a change.
Yeah, and the same. It definitely takes it away from being more digestible when you're covering a bunch of best interest factors that don't really apply to the changes you're alleging occurred.
So we're talking about, for the most part here, we're talking about custody motions, right? Change of custody motions, but how do you handle which standard? Do you talk about the different standards because you just don't know how the court's going to look at it? Or do you just focus on Vadvarka and tell the court about the Vadvarka standard? Jackie?
Okay, sure. I'll keep going first. Sorry, Sean. Next round.
No,
you go.
I like it.
I would say that if I'm filing a motion that is really I'm seeking a change of custody, I absolutely will focus on Vadvarka standard and addressing that. But if I'm filing a motion that's a change of parenting time where there's the potential that the other side could argue that it's really disguised as a parenting time motion, but as a custody motion, I will go into both standards so that I'm kind of saying, for the sake of argument, if somebody says that this is a change of custody, here's why we still have enough to meet Vadvarka.
And I think I may attack that the other way, which is if I'm doing the custody, I'm going to go ahead and put both shades of Vadvarka in there and figure that even if the court doesn't find the threshold for custody, then at least we can move forward, possibly parenting time, and push it under that designation. And I saw Judge Yost typed in a comment asking about the admission of the documents.
So that's a good question. I was going to read it to everybody about how come we're attaching exhibits to our motions when those have not been admitted. You know, what's to get the threshold? Is there a requirement that you present documentary evidence that can be put into admissible form at some point in the future? You know, that would be like a summary disposition standard. Is that sort of what we're dealing with here? Or is it inappropriate to attach exhibits because they haven't been admitted?
And I've had judges go both ways, or referees go both ways on that. And I have had them say exactly what the judge just said, which is these haven't been introduced. I can't look at them. Really, at this point, all I'm doing is taking testimony and seeing if we've overcome a standard here. So you have to cover your bases on that if you're not positive about how the jurist is going to come down on that.
So I have a few polling questions that I think are probably relevant to this topic. So, and I haven't done a poll in a very long time. But let's see if I can work it out. I don't know why they're not in the same order that I wrote them. But let's try this. I'm going to try to launch the first one. And can you see a poll?
Yes.
Yes? Okay,
Yes.
good. Is the judge making a threshold decision or is the referee making it? Okay, give it a minute. People are still coming in. It's not letting me vote.
I tried to vote too.
Oh, well, you get to tell us what you think. So, all right, I'm going to end the poll because it looks like we got a lot of people participating. Share results. Mostly judges or referee. Can you see the results?
Yes.
Excellent. Okay, good. That worked. Yay. So in most cases, it looks like it depends on the county probably. And then a lot of them are being made by the judges. Okay, so let me go to the next question because stop sharing. And I'm just to make sure I know how to do this. Oh, it's not letting me. Okay, let me go back. All right, now I'm going to do question 2. I have 3 questions related to threshold. How often are you obtaining an evidentiary hearing on the threshold?
So Liisa,
Never.
clarification,
Yes?
are you saying just on the threshold issue?
Yes,
not
ma'am.
the best interest
On the
factor?
like an evidentiary hearing to decide whether the threshold has been met, where that evidence that Judge Tina Yost Johnson mentioned could be offered to the judge to help that judge make a decision about whether there's a threshold. It looks like overall, it looks like less than half the time or never are outweighing more than half the time.
Can you share the results on that one too, Liisa?
Do what?
Can you share the results again? I think it's
oh, sorry. How's that?
Oh, thank you.
You think as long as I've been doing webinars, I know how to do this, but because I don't think I've done a poll since we were in lockdown. Okay, I'm gonna stop sharing.
I think that's interesting because in the Macomb, the other Tri-County area where we're at over here, I don't think I've done a threshold hearing, evidentiary hearing. I think those are all handled at the preliminary hearing with most often the referee, unless for some reason the judge decides they're going to hear it themselves. So I think that decision is made by the referees in this area.
I'm going to go to the last question related to threshold, if I did this correctly. Oops, not wrong one. Sorry. Hopefully let me do it again. Back. Must be this one. Okay. Are your counties holding separate threshold hearings before sending the case to the friend of court? So is that maybe repetitive? It doesn't have to be an evidentiary hearing, just like any kind of like time in front of the judge. Most people are saying no. Interesting. All right. Numbers are still coming in.
And I think that's consistent with what I was just saying, which is I think at least in our area here, it's that initial motion hearing in Macomb on Mondays, in Oakland County on Wednesdays, where we get to the referee and the referee makes a decision. In Macomb, you have to wait. In Wayne County, you have to wait after your motion hearing to get objections heard by the judge. In Oakland County, it's usually now, though several are doing it in person. And so you get to go straight in front of the judge afterwards. And that is technically where you might be able to argue that threshold issue. And so, yes.
So we have another question from the audience, and then we're going to switch gears. So the question is about, you were talking about the threshold standards and setting what they are in the motion. And it's about, so often these types of motions become a treatise on the applicable law. This provides a blueprint for the judge or referee, but seems to take forever to process. How do you suggest the moving party reconcile this situation? And I think by process, I think Philip was referring to the fact that they're taking a long time to get a decision on whether it passes the threshold, maybe. That's how I'm interpreting that. Any thoughts about, how to get a decision without clogging the courts with a lot of treatise law that maybe would help down the road, but maybe slows things down at the beginning?
Maybe Sean has a better answer for this one, because in my tri-county in mid-Michigan, most of our courts, at least that I've experienced, they do not have a threshold hearing. It's a decision that's made by either the friend of the court or by the judge, and we just receive a referral order indicating that they've met threshold. So I often see that it happens within a couple of days of the motion being filed. So in my area—
Wait, before a response is filed?
Before there's even time for a response. I've received a referral order multiple times at the same time I received the motion.
Interesting. Sean, do you have any more to say about that?
Well, I think it's all handled at the first hearing. So at the motion hearing, I think the referee who hears that, and I think that may be a bit of the distinction Tyler was referencing in his note there. The referees hear them, and then it may possibly be sent to the FOC.
The investigator or conciliator, as whatever it's called, wherever you are.
Yeah.
Okay, so let's switch gears, because I wanted to ask a question about interim orders. So when we get into these threshold hearings, let's just say it's been sent to the referee for a hearing, and in the meantime, the judge is entering interim orders. I have a polling question. We'll have a little conversation about it. Can you see that polling question?
Not yet.
Poll, oh, it says the poll ended. Okay, well, that doesn't work. Relaunch poll. Okay.
Oh, it's your number 3.
Yeah. Have you, had a judge, entered an interim order without making findings of fact to justify a change of custody or a change of parenting time that impacts the ECE? So kind of mixed results here. Okay, I'm gonna I forget that you can't see it until I end the poll.
Jackie, you want to comment on that?
More often than not.
I guess
or not.
I'm curious if people are almost clustered based on what area of the state in which they're practicing.
Yes.
Because of course I'll mess up the verbiage because the poll screen is gone. But in mid-Michigan, I think there are quite a few times where there is a decision made on an ex parte basis, no evidentiary hearing, and that happens. So that at least is my experience in mid-Michigan.
And I think in our area, maybe it's a little different. I think most of the jurists have heard the Court of Appeals opinions that come down and say that that can't be done without making findings. In fact, I did have a hearing that was set as a preliminary hearing in front of a judge recently, and it was an emergency motion to change, and the judge took it and held a 2-hour hearing to make specific findings, went through all the best interest factors, and at the end of it did make a finding and did decide that a change was warranted. So I think most of the people that I deal with, most of the jurists, have caught up with the idea that you can't do that without making specific findings.
We did just put another poll up just to address Jackie's question about where everybody's located. Kind of just put in some broad categories of locations around the state. So if you have a second to respond to that, that will be the last one. I'm going to end it right now so we can see what people are still, the answers are still coming in. See, thank you, Katie. Yes, yes, I know there's a big difference. I know. I just didn't have time to type up all the different nuances of where people are. Here we go. Oh.
Man, wow.
So, not as many from Michigan. Okay, I'm going to stop sharing. All right. That's it for polls today. So let's switch gears again to talk about the established custodial environment when we're in our post-judgment custody litigation. Jackie, can you talk to us about how you, like when you're like, let's just talk about the hearing. Let's just assume we've passed the threshold and we're having a custody hearing to a hearing to modify custody, whether it's your motion or you're defending it. Tell me about how you approach the established custodial environment.
Yeah, so this is something I know we talked about a little bit during our prep meeting, but to me, I do, of course, ask questions about the established custodial environment. I'll ask about, providing necessities, discipline, and things of that nature. But in my actual hearings, I tend not to spend very much time on those questions or those issues. In my experience, whether right or wrong, in my experience, it seems like the recommendations we receive from front of the court in a lot of our judicial decisions in mid-Michigan, they talk about the established custodial environment, but it tends to be a couple of sentences. A lot more of the emphasis is on the best interest factors. And so I similarly tend not to put a lot of time specifically into the ECE and kind of go from there.
Yeah, and the same, definitely, when you see your orders, it's, the parties shared custody or they didn't share and they make a decision about the ECE. I tend to just automatically assume we're clear and convincing, because I think most of the scenarios that you consider, you're going to need to reach that threshold on these. I think very little falls within preponderance of the evidence at this point if you're looking at custody. So I do, as Jackie said, I certainly go through the questions and certainly make the arguments. But it is one of those that while it's an important, and again, the Court of Appeals made it very clear through the years that it's something that can't be skipped and it's got to be a preliminary issue to look at. But I think it kind of is it is what it is kind of issue, and really arguing, like Jackie said, the best interest factors is where the effort gets put.
I was wondering if you thought, like when you're presenting, you're going through a hearing and you're going to have to put on evidence for all the best interest factors. As part of that presentation, I think naturally there is going to be facts that come out that relate to the child's established custodial environment. So when you're writing your trial brief or your closing argument or your whatever proposed findings of fact, do you just like include something like to point out the facts that support whatever the EC is? Just keep it brief?
I do. I mean, I will reference if it's, what testimony will show or has shown related to the established custodial environment. I'll mention it as well. Why I think it's, in favor of my client or not.
Right, and it's kind of almost a question of, do you just put it out there as a starting point and then move on, which you kind of need to do, versus wait till the information's in the record and then argue it at the end. I think you kind of, like Jackie said, you say, I think the evidence is going to show this, and then at the end you point to your specifics that got you there.
I meant to ask, I have to go back to the threshold for just 1 minute, because I meant to ask your input insights about disproving the threshold. And I think one of you mentioned the possibility of filing a motion to dismiss based on a lack of a threshold. I was going to share a poll about that, but I wanted to see if you had any recommendations. If you're the respondent trying to shut this down before we have to go to a custody hearing, do you have any tips of things that you've done that have been successful.
Sean, do you want to go first this time?
Sure, absolutely. Sorry, you threw me off by saying that. Start, please.
Okay, sure. So I will say that of course it's county and juris specific, but I have had instances where I, filed a motion to dismiss to address the threshold, saying the threshold was not met. And sometimes it can be successful, but I've had other times where the judge's office indicates they don't have time to address it, and it will just go to friend of the court and it can get addressed there. I don't think that the investigator at front of the court has the authority to dispositively address that kind of motion. So I have a feeling it's going to just cost my client months and thousands of dollars to address, unfortunately. But I have, sometimes you succeed and sometimes you don't on addressing threshold like that.
Looks like we have pretty mixed results.
Huh.
Okay, I'm going to stop sharing. We do have some questions from the audience that I'll share with you in just a minute, but I'll let you, Sean, I can see you want to say something. So
thanks. She bumped me back on track. So I think based on how the hearings are handled around here in this area, that issue really gets addressed at the initial motion hearing. And so if I don't think a motion is needed. I don't think I've ever filed one because if there is lack of support for that, then it will be fleshed out at the motion hearing, and the recommendation through the friend of the court, through the referee, will be that this doesn't pass and won't get heard, won't get an evidentiary hearing.
all right, so one of our questions has to do with the ECE. So we're going to going back into the custody hearing again. Have you thought about conceding the established custodial environment and just avoiding that whole time that could be taken talking about it? And somebody that posted, who is anonymous, thought that might be an approach to kind of save time when, as both of you recognize, it rarely is going to make a difference because it's going to almost always be clear and convincing evidence standard regardless. Jackie.
I guess, okay. All right. Well, what I'll say is I don't think that I concede that point very often. I think what I tend to do, or at least aim to do, is to indicate that I think it should be clear and convincing, and here's why. But for the sake of argument, if the court disagrees, then I'll explain why preponderance does or doesn't, they don't meet that standard. But I feel like it's important to at least have your argument and then have the backup in case it's a situation where you don't have another chance to argue under the other standard, what would happen at that point.
And I'd say the case would have to be, here's my legal term I use with my clients, it'd have to be really squishy in the area of the established custodial environment for me to not concede it. I think, and that may be, the person who sent that may have kind of gotten that impression, or at least thought that's kind of what it sounds like, because again, that's my it is what it is philosophy on that. I don't think there's usually much creative analysis or fact finding that's really going to push that one way or the other. So I guess conceding is another way of putting it. I guess I make the argument about what it is to the court, but don't really spend a lot of time arguing about it. So conceding is a good idea.
Okay, so we're going to switch to the best interest part of the custody trial. And I'm looking at some of the questions, and I'm going to try to integrate them because I think they have a lot to do with the best interest. And let's start with presenting your case on the best interest. In addition to the party's testimony, do either of you have witnesses you like to have to make the best case about the modification request? Jackie?
I would say my rule of thumb is I am not a big proponent of having other witnesses other than the parties unless there's a really compelling reason. I think in part it stems from doctors, coaches, teachers. Their jobs, their roles aren't necessarily to eventually come in for testimony. And so I think it kind of can rub the community members the wrong way And especially if you have a post-judgment case that you're almost constantly working on, do you really want to call in that favor, if you will, or ask them to come in every single time you have another hearing? Probably not. So if there's no other way to get information in, then yes, I will lean on other witnesses. But I tend to believe that most of what we have is going to be from the parties. I mean, they know how they interact with the other person. They know how the child is doing, whether their bedtime's an issue now. Every time there's a transition, they can talk about that. Somebody else, I don't think can say nearly as much.
John?
And I guess I kind of look at that a little from the other side is, and I just had some clients I was talking to this last week, and I said, obviously, mom, dad, brother, sister are all going to say about the same thing. I don't think we need all of them. The party will be, but I said, people from the community, somebody from the church, somebody that is a coach, and certainly we have in a lot of the cases here, and I don't know, maybe it's just because we have more therapists available, but there are a lot of therapists. And while they can't, I know there's this discussion about the forensic person, mental health professional versus the therapeutic and who can make recommendations, but I don't ask them to make recommendations. If they're the therapist and they're involved in the case, I just ask them about the specific things, information they have. And we've been able to get them on the record, and I think that testimony has been important.
Now, I know both of you, having busy trial practices, have most certainly faced situations where many clients have handed you hundreds of pages of text messages or tons of, like, I don't know, maybe I'm going to use therapy notes if you have them. And do you have any recommendations about how to distill them or how to use them to support the case that you're trying to make in the trial court? Sean?
Sorry, I was reading the message that gets it's like my phone. It gets a little distracting here.
You shut yours off, I'll pay attention to it.
The question was, how do I sort through it? I've gotten to a point where I try to get my clients to do the document review for me when I can, because I think it has multiple benefits. So let's say they drop on me, 200 pages of text messages because they're not using our family wizard and I can't go through and look and sort. So I then usually will give them the 12 best interest factors, talk to them about it, explain which I would have done before we got to the point of filing a motion. And I say, I'm going to need you to go through these and kind of identify which ones fall under which factors. So I get them to kind of pre-sort them for me, whether they make piles or whether they tab them or whatever. And I think that that's really helpful because I think some of that stuff can be helpful. Obviously, I know we've got some jurists on here today who probably are cringing when they hear this stuff because I've been at the hearing where somebody has tried to just say, okay, well, I'm introducing 100 pages of text messages, and everybody's like, oh my God. So I do try to get them to sort it. And then on the 12 best interest factors, it could be that 100 pages of text messages, I've got a dozen or two that are relevant to the best interest factors, and I kind of use it that way. Reverse engineer, I guess you'd say.
So I have a question, and then we have an audience question. How are you getting the therapist records? Are you subpoenaing those records?
Yes. And I'm getting
and so you're having success in your areas where you're practicing on getting those records?
Yeah. I subpoena
Jackie?
the records. Just wanted to say, and I ask for including therapy notes.
I wish my clients went to therapists near Sean because most therapists will not give the notes to us in Mid-Michigan unless both joint legal custodians sign a release. And often when we're in litigation, of course, kind of responding to Phillips, somebody might not be so reasonable and we won't be able to get that information. So, Philip, I don't only have reasonable clients. Those are the ones I try to attract, but it doesn't always
doesn't, sometimes it backfires. So when you're calling a therapist to testify, this is the audience question from Melissa Pierce. Are you reviewing the agreement to make sure that it doesn't have a provision that if are called to testify, they won't be treating therapists anymore?
Well, and I'll start there because I have reached out, asked, and talked to the therapist, and they say our contract overall does not allow us to get involved in the cases, and so then that becomes the end of that one. So I can try to get the court's subpoena power to do something, but you also need to gauge what you expect from a witness who's not willing to be a witness. So is it really going to be to your benefit anyway?
And to that, piggybacking off of that point though, Sean, one thing that I do is if my client wants to have somebody like a therapist testify and we're getting pushback, as we often do, I also have a practical discussion with my client about, is it really worth it? Right? I mean, if this therapist says they won't see your child anymore and your child struggled to build rapport with a therapist and they have, depression, suicidal ideation, is it really worth it to get rid of this resource for them in the future just so you could have some testimony and to make sure they're making that decision, realizing what the consequences could be?
Right. And like in a case like that, if there's suicidal issues, ideations, or there's usually some medical records that will accompany that again, I've had luck subpoenaing from the medical providers, and I have not run into cases where I've been told you won't be able to get them unless both parents sign off. As long as it's a joint custody case, one parent, I get them to sign a release, which I prepare and always send with that to release the records, but I haven't had anybody say you need both.
So we've been talking a lot about these post-judgment custody trials, but we haven't specified whether we're talking about a trial in front of the judge or in front of the referee. So first of all, I just want to see what your experience has been. Has most of the trial time, the actual time in evidentiary hearing in post-judgment custody, is most of that in front of a referee and then a little bit in front of the judge, or what's your overall experience, Sean?
I can think of 2 trials that I've done in front of judges, with the rest being in front of the referees, and one of those actually being in front of a referee. And then there was a secondary issue that came up after objections, and we did a new trial in front of the judge. So mostly referees.
Jackie, is your experience the same?
Yeah, mostly referee. I think that it helps to kind of address the bottleneck, and some of it gets sorted out before the judge has to use their time as well.
So since we're talking about a lot of these trials happening before the referee, and then the referee makes a recommendation, and then there's an objection to the recommendation, and then you go in front of a judge with a de novo request, right? So when I'm just kind of curious what you're seeing where you are as far as that de novo hearing is. Are those de novo hearings really, are they like a short hearing where the judge has already read the transcripts, or is there oftentimes an opportunity to put on some evidence so that the judge can get a flavor of the party's credibility? How are those hearings, de novo hearings, being handled where you practice, Jackie?
At the risk of sounding very typical lawyer, it depends. I think a lot of judges do restrict what evidence can go in front of them in those de novo hearings, and there are some judges that I've seen that don't restrict, and they allow some evidence that could have been presented at the referee and not other evidence that couldn't have been presented at the referee. So I think it just depends on the judge, and so I think this is maybe a good plug to remind people to make sure you know your judge. Ask around if you're practicing in front of someone you don't know, so that you are aware of what to expect, because sometimes you don't find out until the day of that the judge is going to allow more evidence, and maybe you should have brought something else with you and your client that day.
Yeah, I think most of the scenarios I've seen, the judges understand, or at least I make the argument and they agree. So I assume they do it in all their other cases, is that they can only look at new evidence that wouldn't have been available at the referee hearing, but that they then do go back and review the record. But then I think the caveat on that is that they are supposed to look at it and see if they, I'm going to get the exact line wrong. Lisa, you've probably got it better, but that they're supposed to see if they would have reached a different determination.
So in the context of post-judgment custody litigation, where's the bulk of your time as an attorney being spent? Like what part of the process is really like the part that takes up most of your time? Jackie?
I think just sheer number of hours is often weeding through the stack of information the client gave, some of which is relevant, some of which is actually harmful to their case, and they just give you everything because they don't want to read through it and help you weed that out.
Sean?
I think that was such an important, I think if there's anything to put like a big star next to what Jackie just said, which is your client's going to give you tons of information, and what you have to do is spend the time going through it. And some of us have assistants that can do some of that filtering, but nothing can take the place of you putting your eyes on all of that stuff. Because I just was doing one this week, and in it, I'm going through hundreds of pages, and there's this one piece, and I'm like, yeah, if we had turned that over, or if I just attached that, that would not have gone well. And it wasn't anything that I didn't want. It wasn't anything I was obligated to share and didn't want to, but when I'm setting the message, this wasn't part of the message I wanted to set.
So before we switch gears to our last topic, there are some questions. So they're kind of not necessarily in order, but they're relevant to what we've been talking about today. So I'm just going to get them out there. One, have you seen, or how do you handle when one party is using a PPO as a basis to get a change of parenting time?
I'll start on that. I mean, it's become kind of, I joke with the clients when it's appropriate, but that this really seems to be kind of, there's a textbook out there about how to get a change of custody, and PPO seems to be like chapter 2. And
what's chapter 1?
Right. Deny parenting time. And so to get that, it seems to be used more and more in a lot of these cases. And I do feel bad for the jurists who have to sort through all of these because, and then I've got one just this recently where the one case is in one county, but because that was where the case was, but then they filed a PPO in a different county. And now we're kind of having to divide our efforts on that.
Yeah, that is an issue that I've seen many times where the PPO is not in the same county, or even if sometimes if it's in the same county, does not mean it's in front of the same judge. I mean, I want to hear what you have to say, Jackie, but I'm wondering if there should be a requirement if there's a domestic relations case pending between the parties that the PPO has to be filed in that case.
So I think to that point, I think part of the reason there is the flexibility about filing PPOs is so that the, I guess, victim of domestic violence is able to access the courts in a way that's easiest for them so that we're not putting additional burden. But I do think it's important that if possible, judges from different counties can talk or give information to each other, or that at least it's disclosed on the filing documents that the PPO is in another county so that information can be in front of the judge. I will say that in my experience, when the PPO is filed in the same county in which there is a pending domestic relations case, it seems like the Mid-Michigan courts are pretty good about the one family, one judge and reassigning cases before decisions are even made so that the judge is able to address it. And I have seen many times where the court will require a hearing within 2 or 3 days on that PPO request because there's pending litigation in a custody or divorce case.
Right. Okay. And then going back to the topic where we're with the therapist, the question from the audience is asking if there is case law that says only one joint legal custodian needs to provide consent to get the release of those mental health records? I didn't know the answer off the top of my head. Do either of you know the answer?
Well, I would shift the burden there. I would say, is there case law that says that both are required? I mean, you're a joint legal custodian and you want your child's medical records. I mean, it seems to me that it would be an absurdity of the law that if you're having to get the approval of somebody who's contesting you at every step to be able to access your child's own medical records, that just doesn't seem to make sense.
Okay, so we only have like 13 minutes left, but we have a really important topic that we probably could have spent the whole time on, and that has to do with how do we keep these cases moving along? We all know here in Michigan that these custody cases, especially post-judgment, are taking a large amount of time. They're being spread out and sometimes take, a year, even 2 years to get a decision. So let's talk a little bit about what time limits there are, and then what can we do to help the court move it along faster. I think as an introductory comment, I just wanted to say that it's my understanding that SCAO has time limits for judges and courts regarding initial custody decisions and original divorce cases, right? And so I feel, and tell me your experience, but I feel like the judges are very carefully monitoring the status of their cases that are pending when it's in that pre-judgment phase. But like we said earlier today, most of our cases are in the post-judgment world, and the SCAO, for whatever reason, is not tracking that at all. So I don't know if you have any comments about your experience with the length of time it takes to get a decision and to complete a case in the post-judgment world.
It
Sean?
takes too long.
Oh, it takes too long, yes. More? Do you have something more to say?
I mean, I without details, I mean, there are instances, including one now, where I filed a motion to change custody in part related to domestic violence and drug use. And that motion was filed in May of 2022. And we're still waiting for a referee recommendation when we submitted written closings 8 months ago. And so we're just sitting and waiting. And there's the practical point, I think, of how much do you push the front of the court or even ask the judge to get involved if that could have some sort of effect on what is recommended. And so client and I are just waiting right now.
Right. So the referees do have a time limit that are applied to them, and it doesn't seem 3215E doesn't seem to apply only to pre-judgment. But we have the sticky situation of we're waiting for a decision. How much pressure do we want to put on the person who's going to be making that decision? Sean, do you want to pipe in?
So I think, we've got, I guess I'd say as a starting point, one of the issues, and I'm sure every jurist faces this, is the labor force availability. I think that there's a shortage of referees, whether it's slots unfilled or just not enough slots available to handle the caseload on this stuff. And as you pointed out, Lisa, I think there's a challenge there. I mean, I'm sure they're counting these post-judgment cases somewhere, somehow, but it doesn't seem that it gets properly allotted. And maybe that's because the referees are assigned to the judges based on the judge's pre-judgment caseload, not post. But I know that in the counties I practice in, there's a delay in getting scheduled, and it kind of cycles up and down. And so some counties are quicker sometimes than others, but it definitely does have this issue. And somebody just pointed out, I saw the comment, you do end up with sometimes 3 to 5 trial dates, and those trials being sometimes you only get an hour or two in at a time. And so obviously that's a case management issue, but it's what they have to do. And so or the downside, the other side of that is you can get your 2 days back to back, and those will be in 3 months. So, but with all kindness, I understand the limitations that everybody's working with, but the question is, how do you, as Jackie said, how do you kind of nudge people or, be the squeaky wheel when that might have a negative impact on your client?
That is the rub. I mean, one idea, and I already know what I think about it, and I have a feeling you feel the same way, is doing some sort of motion with the trial court when, well, in the example you gave, Jackie, it's been 8 months since the close of evidence in a referee case, and you still don't have a referee recommendation. So, I mean, what about, I don't know that it'd be a good idea, but filing some sort of motion in front of the judge to get the matter decided.
So to that end, I will say is that is something that I've brought up to the client as an option and presented that with the positive and negative potential. And that way they have in writing made that decision for us about what to do, so that they're not upset with me.
Fair enough.
And I will point out, just as an overall issue, one of the things Jackie just said, I think is a really important issue is, I tend to try to present almost everything with my clients as a cost benefit analysis. And it's the phrase I use with them, and it's kind of how I present it, is that, anything can be done within reason, but there's going to be repercussions, and we've got to take a look at the landscape.
Do we have any thoughts about why, other than staffing issues, and that's like very understandable, and we feel bad about that. But is there any other thoughts you have about why it's taking so long to not just finish the hearings, but then also get a decision in these post-judgment custody cases? Go ahead.
Sorry. I think part of it, the reality is that the timelines that they have in pre-judgment cases are so stringent and so carefully monitored that it's easy and understandable why post-judgment cases just get backburnered over and over again, because I think, unfortunately, our courts are so often in triage mode that they can't really get to the other projects or opinions that they need to be working on.
Right. No, I think that that's true. And that if there's, nobody counting the days on how long it takes to get a post-judgment case handled, then I think that in itself, kind of allows such a broad range of handling, and maybe there could be some guidance there at some point.
Now, I know when we chatted the other day, we talked about some ideas that both of you had to help keep the case moving along. Sean, can you tell us about one of the things that you do? You mentioned something about scheduling orders. Or I think it had to do with maybe it was the other way around, but like I thought not all counties, not all courts use scheduling orders.
Correct. Well, and in the referee hearings in some courts, some counties are better than that at others, but even I think within the counties, there seems to be a little bit of discretion between the jurists about how they issue those. But I actually asked for them, and most recently in a court was calling because I got a general, here's a date for a custody parenting time hearing, and that's all it said. And so I followed up, and I'm like, what are my timelines on this? Are we submitting a witness list, exhibit list? How much time are we allotting? Am I going to be able to call witnesses? And then at the end, the statement was, well, it's really to look more at support. And then when I went, it was really that they were looking at the issues, but no evidence was taken. And it was really just going to be a front of the court recommendation. And it covered parenting time and support. So I try to get them to give scheduling orders and try to, I don't want to say hold them accountable, but follow up with people to know what to expect. So my clients know what to expect, and we can meet our deadlines, timelines.
To that point, I think that if there was more of a knee-jerk or an always situation where the post-judgment cases, there were scheduling orders, I think it would be helpful. It is frustrating when you get to a referee hearing and, you don't know any of the witnesses that will be there until they get called. And so you're feverishly whispering to your client, trying to get information because you don't even know who this person is. And
first of all, that would never happen in any other kind of case. Seriously, that is like outrageous. Okay,
yeah.
Sorry, go ahead.
No, okay. That happens for when the referees, sometimes they find out there are a lot of exhibits. They say, okay, we'll take 10 minutes and see if you can stipulate to the admission. And you have 100 pages, you think you're going to skim read and be able to make those decisions. So I think scheduling orders could be really helpful. And I do think that if we were pushed to give witness and exhibit information in advance, you couldn't have your big surprise moment during a hearing. But I think maybe some of our cases might resolve beforehand if you see the mountain of evidence that somebody has, or maybe we'll both work towards settlement a little bit better rather than, think we're going to surprise you at the hearing.
Well, I do want to hit that point on the exhibits, which is, the most important, or at least equally important as the testimony of the exhibits. And yes, I mean, in some of these courts, you're allowed to just be blindsided with that stuff. And I think that it is important to ask for the jurists to ask the attorneys when they're represented to look at those things in advance and to stipulate to some of them. And I know some attorneys are just like, well, I'll never stipulate to anything. But in general, that exchange is what helps you prepare for the evidentiary hearing. And so if you don't know what to expect, it seems like it's almost a guaranteed mess. I'll use that word, mess.
Are the referees ever having conversations with trial counsel about like, okay, how much time, how many witnesses, and how long do you think you're going to need to put on your case to get, and then the referee or the judge, I guess, depending on how it's being presented, can say, oh, you think you want 10 days? Forget about that. That's way too long. I'm going to let you, like, you can do this in 6 or 5 or what, how many ever hours. Is there any of that kind of conversation happening in cases without scheduling? Maybe it's just the ones without scheduling orders.
Right. I think that that's the point, because I think I can think of several of the courts locally where they will hold what amounts to a pretrial on that, and at that pretrial
By the referee.
With the referee.
Right. Okay.
Or they will, if they don't do it, then you're at least getting some kind of scheduling order.
Are they also, if there is something like a pretrial or not, are they saying these are the 5 dates that I've set aside, the 5 afternoons I've set aside over the course of the next 3 months? Or is it like you go in for the first thing and you find out how far you get, and then at the end of that, it's 5 o'clock and everybody's ready to go home. We're saying, okay, we're going to come back. Let me look at my calendar. We're going to come back in 6 weeks. How is it going down, like as far as getting the actual time in front of the jurist? Jackie?
I would say for me, it seems so in my counties, we don't have scheduling orders in our post-judgment cases. I think that a lot of times the referees I've seen that, if you ask for it or ask for a conference in advance, they'll do that. But a lot of times, the other side might make it harder and put up barriers to you having that conversation. So you can't have it until the first day of the hearing. And then, even if some information is exchanged right then and there, the clock's already ticking. And so there's a lot of pressure to try to make decisions quickly or to look at exhibits right away. So I think that's for my experience.
Okay. And I think the courts, just to say, I think the courts that are doing the pretrials, and they are the ones also who are setting a day or two aside. They're just kind of what you were asking, Lisa. They're not the ones who are doing this 5 days thing. It's the courts that don't generally issue a scheduling order and kind of are playing it a little more loosey-goosey. You come in and find out you have 15 cases that morning on your first day of trial, and then you're going to get an hour if you're lucky. So
I'm getting a lot of comments in different places about the scheduling orders, and I did want to clarify, as somebody posted, referees do not have authority to issue scheduling orders that require anything. So what I really think is that it needs to be the judge who has some sort of scheduling order about what it might look like in front of a referee, potentially. And then there's also been a suggestion to modify the court rules to allow referees to issue scheduling orders. So that's something to consider. we're really out of time, but I wanted to bring up one more last point because there was a suggestion. I think Sean, you made it about doing a findings of fact and conclusions of law. If you could address that, and then we'll have like our closing comments.
Yeah, having done it both ways, and by both ways, I mean just having basically your closing argument on the record, and then also having jurists who have offered the alternative or said, I'm going to ask you to go ahead and submit a written findings of fact and conclusions of law. Having done it the first time, I do recall it was very difficult because you basically have to go back. But when you've got, let's say, 5 days of testimony, if this is a case where you've been doing it in pieces, I think that it's really helpful to be able to put that all into perspective, put them in their right categories, even if it's not in chronological order, the testimony, and to be able to hit that. And I think that if ever, and I recommend it to the jurists, that I would, I'd be happy to submit written findings of fact and conclusions of law, because I think it really helps you solidify the record on that. And you don't have to worry about whether the jurist remembered a specific fact or not. It's there now.
Jackie, do you have any closing thoughts?
I don't. No.
What about the findings of facts and conclusions of law?
I haven't really done them in my cases. So, I mean, I've had closing arguments that are oral or written, but I haven't been asked specifically about findings of facts, conclusions of law. So I would defer to Sean on that.
I mean, it does sound like a lot of work, but I think your point is well taken, Sean. One last quick question about that. Do you usually do it based on all your notes from the trial, or do you order transcripts, or how do you go about preparing that?
Well, and I'm able to do that because basically I transcribe, I write really fast, and I don't use a computer, which I may switch to at some point. But I write really fast. And so when I get done with 5 days of trial, I've got 5 yellow pads of notes. And so
You must be able to read your handwriting.
Well,
like
there's that. So I'm able to basically say witness number 1 said, and then put it all on it.
Great. Well, Jackie and Sean, thank you so much for being with us today. And I apologize for going a couple minutes over. I'm usually right on time. So, but I really wanted to hear what you guys had to say about making the cases move along faster. So thank you all. I'm going to end the recording.
Thank you, Lisa.
Thank you.
I think I'm ending the recording.